legal counsel. I guess two questions. The first one, just so I can understand this better from a legal perspective. Is it true that county land use laws and regulations are not enforceable against the federal government or any other local jurisdictions?
It's not necessarily true that they're not enforceable against other local jurisdictions. There's a distinction, I think, between zoning and development, but so there are possibilities.
Possibilities.
But the issue here is that this law, this is city land that is ruled by state law, and so it's really the state law issues that obtain here. The Metropolitan District is a creature of a series of state laws that have been passed, starting, I think, in something like 1908 through 1924, and I don't believe that the county has the authority to require this.
If I could ask one more question. Well, to follow up on that question, then, just to make sure I understand it, if it was the federal government, then it wouldn't be enforceable, but with other local jurisdictions, there could be some question on that. Did I understand that right?
Yes.
Okay. And then the second question, say, for example, the city of Baltimore decided that they were going to permit mountain biking in the reservoir. Could they do that with or without Bill 22-12?
I think that they could allow it. I also think that one of the problems is that 2212 is really not the best vehicle for accomplishing this. This forest buffer law is really about what happens when somebody is about to do some development and there's a requirement to install a forest buffer around a street. So I mean, I've heard a lot of talk about this thing being a forest buffer. It's not really clear to me that the property that we're talking about here is a forest buffer under Article 33, Title 3 of the Code. What happens with that law, and the law that we're talking about here, is that an applicant decides that he's going to do some development and it has the potential to impact the stream. It invokes this forest buffer law, and there are requirements within the law to create a forest buffer, to create covenants and easements and all that sort of stuff, which is not really, which is what this law is really designed to do. There's a covenant document that needs to be filled out and filed. So I'm having a little bit of a hard time answering the question because I don't agree even if the idea is out there that the county could limit or could limit what the city could do on its property within Baltimore County. I don't agree that this particular forest buffer law is the means for doing it. This law is very, very much about a developer triggering a process that leads eventually to the creation of a forest buffer around a stream that needs to be protected because of the development. So this isn't really the vehicle for doing this. I haven't said a lot about that in the past, but that's one of the things that I have about this bill.
Thank you. Any other questions?
Madam Chair.
Yes.
Mr. Fields, did you have that discussion with the sponsor of the bill?
2 days ago. But I got the opinion last night.
Is there any other avenue that he could pursue that would obtain his objective?
Well, I mean, on one leg, I would still suggest that the law involved here is really state law, and that the better thing, I think, is to go through the General Assembly. There are provisions of what is now Article 20 of the Code is state law. Baltimore City also has a series of what they call public local laws that you can find on their website that I think also would probably have to be amended or at least looked at in order to really accomplish what you want to accomplish.
I think